Welcome everybody this morning. A little bit of formality here to start with, and then we'll get a little bit more informal. Today is January the 14th, 2015. This is the first meeting of Rulemaking Working Group, Group 1, Priority 1, to discuss the following rules under review, which is 12.6.1043K, which is a motor vehicle dealer board regulation, 12.6.5041MI, which is a motor vehicle dealer board power sports regulation, 12.6.118.3V, which has to do with acceptance, rejection of a financing regulation. That is also a motor vehicle regulation by the board, and 12.6.523P, which is the sister regulation in the power sports area. This is the first meeting of several that will take place, and I've got a little bit of discussion in item number 2 of the agenda, but before I do that, I think we need to do introductions. This meeting is recorded, so make sure that you are close enough to a microphone that the recording can pick up your voice. But I want to go around the room and have everybody introduce themselves and who they represent, who they work for, who they represent. I'll start off by, obviously, I'm Bruce Zuloff, Director of the Auto Industry Division.
This way. I'm Chris Rouse with the Auto Industry Division.
John Shendon, former dealer.
Jerry Abood, representing the Power Sports Dealers Association.
Michael Domermuth, dealer attorney. CADA, sorry, forgot my client.
That's no problem.
I should have just let her introduce me.
Okay, I forgot you last time and didn't give you time, so I guess we're Tammy McCoy, New Car Dealers Association.
Todd O'Connell, Used Car Dealers Association.
Mike McKinnon, Used Car Dealer Association.
Barry Marvin, manager of Colorado Automobile Power Sports Support Services Association for used car dealers.
Steve Perkins, used motor vehicle dealer.
Rick Weincoop, Used Car Dealers.
Matt Heath, Auto Industry Division.
Thank you, everybody. When I put this group together, the goal was to try to get a diversified group of people together from various, representing various aspects of the industry. Obviously, the 4 associations were invited, and their council was invited, and they're all in attendance. I also wanted to have 2 former board members involved from the standpoint of an understanding of the board's dynamics when it comes to rulemaking. And then also I wanted to have some balance, to attempt to have some balance on the consumer side of things. So I invited Mr. Weincoop, obviously, as a respected consumer attorney around these issues, and I did also invite 2 members from the Better Business Bureau that have not responded back after several requests for them to be in attendance. The Attorney General's office will be represented here today. Ms. Scott, Mr. Cherry will be here. I expect them to walk into the room at any time. Just so I kind of set the record straight, when they get here, they will be active participants in this group for as long as this group meets. They are legal counsel for the Auto Industry Division and the Motor Vehicle Dealer Board, so they can express opinions about language, those kinds of things, but they cannot give this group legal advice. So just need kind of to know that. Discussion on process. Obviously, this is the first time that the Auto Industry Division has done a stakeholder meeting with these dynamics that came out of some fairly recent legislation, 2 executive orders by the governor and the Department of Revenue's new policy, fairly new policy on rulemaking. What I'm doing right now is just kind of rambling to make a record here, but what will take place is we will go through these rules over the course of the next 2 or 3, 4 meetings, whatever it takes. We will attempt to have a collaborative discussion around these issues. We will attempt to reach some kind of consensus on whatever we can reach consensus on. At some point in time when this group's work is done as a stakeholder group, the division will get together with the division SMEs in the Attorney General's office, and we will draft the rules, either modify the rules, additional language. Maybe the rule does not need modification. The division will make that decision based upon this group's work. And then we will notice that rule. Once the rule is noticed, then the formal rulemaking process takes place. It is uploaded to the Secretary of State's office, and then there's timelines that happen after that those documents are uploaded. There will be a starting today with this meeting, this recording, the documentation in front of you starts the formation of a rulemaking record. Virtually everything that happens in these meetings and all documentation that is brought to these meetings, exchanged, and future emails will all become part of the rulemaking record. The rulemaking record will eventually make its way to the board before the public hearing, and so they will have all that documentation in front of them at a public hearing if it gets to that point. So there could be a pretty voluminous amount of documentation and recordings in front of them. What we will do at the division is the recording of this meeting will be uploaded onto our website probably about within a week, and the minutes of this meeting will be uploaded onto the website. The minutes will be very general in nature. Obviously, the recording is going to be as the recording takes place. The board has indicated that they want that process done that way so they can listen to the discussion. But obviously that goes out to the world if whoever wants to listen to that when that recording is uploaded. That is the way that the Department of Revenue has decided to move forward in an effort to be as transparent as humanly possible. Any questions on that part of it? And then I'll get into a little bit more here before we open it up for discussion. Any questions to this point? This meeting will last 3 hours. I will adjourn this meeting as close to noon as I can. And about 10 minutes before noon, I'll find a proper break place, and then we'll decide when we can meet again. Jerry and I had a little bit of a humorous moment. The last time we did this, it lasted 18 months, and this will not last 18 months. I can make that single guarantee this morning. This process needs to not carry out over about 60 days. I anticipate that we will need to meet 3 or 4 times. Past the 4th time, I don't know that we are really making any progress. We'll just see how it goes today and in the next meeting. I realize that everybody's schedules are busy. What we will do is at the end of this meeting, we will try to find a date that works as close to for everybody as we can, but it really does need to be in the next 2 to 3 weeks. This group has to end their task, I think, within 60 days. Generally speaking, once this process starts, it is 6 months before a public hearing takes place, around 6 months, okay? So this is a 6-month process. So we will attempt to do the best we can in a collaborative manner. I will take breaks as close to the top of the hour as I can make that break. Breaks will be 10 minutes long. And so we will have a break at as close to 10 and as close to 11 as we can get. Okay, well, I think the next thing I would like to point out is the agenda. You all have an agenda in front of you. This agenda will be posted on the website at the same time that the recording is. In the future, the agenda will be posted on the website in advance of this meeting. We've done welcome and introduction, discussion of process. I'm going to go over the group discussion guidelines, which is the second part of the agenda. We'll talk about the working group meeting scope, and that's really the crux of what we need to talk about today. And because this is an open meeting, the public, if anybody from the public does show up, there's a sign-in sheet for them to sign up, and at the very end of the meeting, they can make a comment if we have time. So let's talk just in general about the guidelines, which is the second page. This is the guidelines that several of the other divisions within the Department of Revenue are using. Only the working group members may participate in the discussion. And so that's the people sitting at this table. Okay. Time will be set aside for non-members to speak during public comment at the end of the meeting if there are people in the audience. The agenda for discussion will be strictly enforced to ensure that we are able to cover all the topics on the list, and that really is in Group 4 on the agenda. Finally, I need to ask everyone, the group members, those in attendance, to be respectful of each other during this process. Remember, the meeting is recorded, so everyone needs to respect each other's time when they're talking. Attempt not to interrupt anybody so a clear record can be created. If anybody from the public ever wants to address or make a comment at the end of the meeting, they must sign in at the sign-in sheet located at the table at the front door. Given the time restraints, there's no guarantee that everyone will receive the opportunity to speak, but I'll do the best we can in an effort to be transparent. Redundant or duplicate comments will not be allowed. If someone expresses support of another speaker's comment, I'll ask them to be brief and not to repeat prior comments. I will cut off anybody that is abusive or argumentative and ask them to leave the room. Comments may be limited to 2 minutes per person, depending on the time that we have. And individuals cannot give their time to somebody else if we get to the consumer comments. Questions at this point in time? I see Ms. Scott has arrived from the Attorney General's office, so I'll let her kind of introduce herself and her title and what her part in this group will be.
Well, I think basically everybody knows I'm Y.E. Scott. I'm with the Attorney General's office. I'm also General Counsel to the Motor Vehicle Dealer Board.
And Ms. Scott, I've already let everybody know that you are General Counsel to the division and the board, so you can express comments here, but you cannot give legal advice to this group.
Right.
Okay, the other document in front of you, the single-page document, is the 2015 rulemaking agenda. This is page 1 of a 7-page document that the division is still working on as of yesterday. This document will be, I believe this document will be done at the end of the week. This will go on the website. This will be provided to the board. It is a working draft schedule. What we have before us, what the division has as part of our charge in the 2015 calendar year is we have, at this point in time, 39 rules that we are expected to review. in one way or another. This is Group 1, Priority 1, so this is 4 of the 39 rules. The pages that you don't have in front of you are still under some review, but that will be, like I said, posted on the website. What the division has done is gone in and looked at these 39 rules and tried to group them into logical groups for these types of meetings, these types of stakeholder meetings. Of these 39 rules, there are a number of the 39 rules that also are EDO rules, which is obviously the rules of the executive director. Remember that the executive director is the state licensing authority for manufacturers and manufacturer-related licenses. The Motor Vehicle Dealer Board is the state licensing authority for dealer and salespersons. So the EDO has rules that the division is responsible for too. Those rules are one of the groups, or probably 2 of the groups that the division will have to tackle at that point in time. Some of you at this table will be invited to that rulemaking group. Some may not, but some will to the EDO rules. But the point I guess I'm trying to make is that the division is responsible for conducting the rulemaking process for both of these state licensing authorities. Okay. Mr. Cherry, can you take a seat someplace? At an open seat, wherever. Randall Cherry has came to the table, and he is one of the attorney generals, and I'll let him introduce himself. He needs to have a microphone fairly close. Mike, can you hand a microphone over to him so he can... Mr. Chair, if you'll just introduce yourself and what your title is and what you do.
Hi, everybody. My name's Randall Cherry. I'm a First Assistant Attorney General. Part of my duties is the Motor Vehicle Board. I'll be assisting as much as possible in this whole process, particularly with regard to the EDO rules, I think, but I hope to be around as much as possible for all of it. So any questions? Whitey is our guru and expert in this area, but I'm there with her, so whatever we can do to help, we're here to do. Thank you.
Thank you. Any questions from the members about the agenda, the general guidelines, or page 1 of this grouping to this point? Okay, let's kind of get into the nitty-gritty and look at agenda item 4, which is the scope of this group. Scope of this group is to look at basically two rules and the sister rules, 4 total, from the power sports. And that is, we have a rule and regulation for the purposes of the recording is the same. They are interchangeable. A rule is a regulation, and a regulation is the rule. We refer to rule making, but when it comes out and it becomes promulgated, it is a regulation. Okay. So we're looking at Form 2434, and the issues with 2434 are bailment down payment may need to be clarified. We also need to talk about the conflict that the form may have, and in the minds of the division is there, with the statute 61708, which is part of the Consumer Protection Act. We need to talk about the interest rate. Should that be consistent with the finance agreement, the Form 2434? Should the timelines and the rates be consistent within the contract and the disclosure form? Can we remove the form from the regulation? Can we create a regulation that may refer to the form, but the form is not part of the regulation? It's a question. And is there a need for the form at all? The balance here is the division will always try to create balance between dealers and the consumer, but if we are going to err, or if the division is going to, on a 50-50 take one side, we're always going to look at the consumer protection issue. That's what the division does first and foremost, okay? So what transpired a few months ago is that we made an attempt to look at all of this. There was some drafting of new language into a rule. We started a rulemaking process. We had a stakeholder meeting that included the board, and under the policy can no longer do that. The Attorney General's office drafted some language, drafted some changes to the form in an attempt to be as collaborative as possible. And when we got too close to having a hearing, what happened was the division was a little overwhelmed with responses from the industry, consumer advocates, to the point that we realized that the chances of getting something to the board that was reasonable without major public debate, and public debate is not it's not necessarily a negative thing, but we became overwhelmed at the last minute, so I took it off the table and decided to do what we're trying to do today and take a new look at it, a fresh look with a new group of people, and move forward in that direction. Now, with this scope in mind, I may be done rambling and allow other people now to jump in. What the division has experienced in the past, quite frankly, is we are very concerned, have been very concerned with Form 2434 and the conflict with 61708 around the down payment and the bailment issues. The consumers that we have that have complained to us in such a manner that we think there is a major conflict or a major misunderstanding, miscommunication between the form and what a statute says. And of course, the statute, we all know that the statute is always going to trump a regulation. And there was major debate around the whole issue of 126118 and the rejection of the financing. We had real concerns around renting a vehicle, so to speak. Dealers knowing that in the first hours of a car sale that there's no way that they could truly get somebody financed, so they put them in a vehicle and sent them on their way and had a bailment agreement per Form 2434 and recalled the vehicle and knew that they were just renting it at elevated levels. And then we've had a lot of complaints over holding the down payment for ransom, so to speak, when 61708 says you can't do that in terms of bailment. Spot delivery issues, all of those kinds of issues. So I'm sort of done rambling at this point in time. Open it up for discussion. And I guess what I would like to start with is anybody that has any kind of statements around Form 2434 and 61708. And here again, if you comment, please grab a microphone as close as you can. So, Mr. Abood, so.
Very quickly, 61708 has never applied to power sports. Does it need to be amended for uniformity and for enforcement purposes, to be amended to include power sports. Do you believe that's a good idea?
Jerry, I've never been asked that question, I've never been, I would have to look at 617, before I answer that question, I'd have to look at
That's fine.
6178.
And I didn't expect the group to discuss that. I'm bringing up that for purposes of your ability to, and your statutory authority to promulgate rules that involve not involve 6107, but are compatible with 6107.
Because 61708 specifically refers to as a motor vehicle. Got it.
Okay, that's the end. I don't want to take anybody off track.
Okay.
It seems to me that that is relevant to the discussion, but not necessarily the focus of the discussion.
Okay.
I don't see, this is Mike Domermuth, I don't see a conflict between DR 2434 and 61708. 61708 only comes into action if a dealer guarantees financing. It does not apply if the dealer does not guarantee financing. All of the retail installment sale contracts that are in use today are conditioned on financing approval. And that contradicts or undermines a claim that a dealer who spot delivers a vehicle with a retail installment sale contract guarantees that financing. So I don't see any conflict there. Now, there may be situations where dealers do guarantee financing, where they make oral statements to a consumer, which says, you know, we'll get you financed, don't worry about it, this car is yours. That could very well happen. But I will tell you, the paperwork that's in use by dealers today makes it clear that financing is not guaranteed. So I see no conflict whatsoever between 61708 and DR 2434 and the statute that authorizes or requires the use of 2434.
You know, I would just, this is Tammy with the auto dealers. We're supposed to introduce ourselves.
No, not necessarily.
And that was a point I was just gonna bring up, and as a matter of fact, I just kind of stumbled across that on the Attorney General's site the other day when I was looking for something else, just what the current guidance is and what is our understanding of what the law says right now and what it doesn't. And it, per Mike, it's always been our contention that the dealer does not have to absolutely return the down payment unless they erroneously guarantee financing when they should not have. And other than that, they can retain the deposit. And right now, the guidance on the Attorney General's site says failing to return a consumer's down payment if financing is not approved. And I don't think that is accurate. I think it's if not approved and the dealer represented that the financing was guaranteed would make that statement true. So I think there is a question of like what does the current what do the current statutes provide and what don't they?
And I'm not going to spend a lot of time commenting, but what we hear from consumers is that they sign this form too quickly, and what happens is when they walk out the door, they sign a finance agreement or a contract. They walk out the door. There's a temp tag on their vehicle, and they're given keys and say, have a good time with your car. So it's that meeting of the mind. When is financing guaranteed and when it is not. It is certainly not guaranteed if you don't spot deliver. If you don't spot deliver, there is no financing guaranteed. I think there is an argument, and I think there's an attorney in this room that argues that once that temporary tag is put on that and the keys are flipped to a consumer and he goes out the door, that in their mind, they've made a car deal.
It actually goes a little bit beyond that, in my opinion. The disclosure form, I think, is needed to be paired with the buyer's order, purchase order, whatever you guys individually call it. Once a dealer enters into a retail installment sales contract, the customer is financed. The installment sales contract might have a seller's right to cancel on the back, which is pretty not the best form of disclosure, but you're financed with a condition subsequent. But once the dealer puts their name on a retail installment contract, they have agreed to provide financing. Now, what the dealer then does is they go into the market and they look for an assignee, okay? There's a fundamental disconnect between what the Truth in Lending Act says and how people are operating on this. In every retail installment contract, you have one creditor, and that one creditor is the person who makes the Truth in Lending Act disclosures and who is initially payable, who the contract is initially payable to. Every one of you guys that are doing these things are putting your names on that retail installment contract and then turning around and selling them. When you put your name on the retail installment contract, you're a creditor. You have now financed that person. Now, you may finance that person with a condition subsequent that we're gonna go out to the market and try and find, someone that'll buy it. And you can always find someone that'll buy it. I love asking this question in a deposition. I'll buy the thing for $100. Will you sell it to me? Well, why would you sell me with a $40,000 contract for $100? Okay, the point is, you can sell it, you don't like the price. Okay, you guys all know you can kiss the paper, buy down the rate, do all kinds of things to sell contracts. There is no guarantee you're gonna make any kind of yield spread on it, or you're gonna get out exactly what the terms are. Y'all know what a contract rate and a buy rate is. You can always sell the contract, you can discount it as much as you like, and someone will take advantage of it. But once a dealer puts themselves in that upper right-hand corner and says they are the seller/creditor, they have guaranteed financing. Bruce was talking about consummation. The statute talks about consummation in a couple places. Talks about, let me see if I can find my thing here.
I can tell you, it's on a temporary permit, it's under the 45-day permit upon sale of a motor vehicle or only upon consummation of a sale.
Right.
The temporary permit part.
That's the temporary permit, and that also goes back to when we're talking about K here, which is the board's power. And under sub E, except as otherwise provided under Part 1, Article 1 of Title 6 CRS, when the purchase price of the motor vehicle is not paid to the motor vehicle in full at the time of consummation of sale. So, in consistency, you deliver a temp tag and you have a finance contract, you sold a car. You've agreed to finance a car. Again, that financing may be contingent upon some condition subsequent, you're gonna assign it. But for the purposes of bailment, deposit, down payment, whatever you're gonna call it, a financing deal's been completed. But once you have entered into that retail installment contract, my position is you give up all rights to any bailment charge.
Bailment charge, Rick, is in 118. The legislature said dealers can charge bailment.
Up until financing. And once you enter into a finance contract, there's financing.
But let me
Go ahead.
jump in. Here's one of the problems, is the regulation, and again, my view has always been, originally the regulation was adopted to go into the buyer's order to allow for bailment for dealers to charge that when financing is not approved. But if you look at, and it's not that it wasn't in there, but if you go on to look at the regulation under 5E, it says the following transactions are excluded from the application of using the form. Sales in which a retail installment contract with all disclosures required by law has been executed at the time the purchaser becomes contractually obligated to purchase the vehicle. Now, the question becomes are these conditions subsequent type of transactions where there is no contractual obligation because there is still a condition that needs to be met? Or at the top of the retail installment contract says, this form is to be used only if you haven't been given a fully executed retail installment contract. To me, I've always maintained, and I've got one of my dealers that we do this, we don't use this form, we never have used the form, we've put it into the buyer's order. Because we didn't, and Rick brought up a unique situation, because there's too much that contradicts the statute, the regulation, and the form. The first thing is, again, there's always been this argument that you put up to 21%, you'll finance them up to 21%, and that's not the same thing as on the retail installment contract. Well, now that you've got a cancellation part of the retail installment contract, the minute you can't assign that contract at 10% APR, you're canceling it. So this form, really, other than the fact that it provides for bailment, has no use whatsoever. So to me, the question becomes are you guaranteeing financing by going ahead and giving a temporary permit on the thing, Rick, that's been your argument, I get it. I would go back and potentially amend the regulation of a temporary permit to say you may issue a temporary permit pending financing approval. So I'm gonna try and take that out of your bailiwick there. You get rid of, those type of claims. Or I get rid of the form completely and I put bailment into a buyer's order. And I keep the conditional financing approval as an assignment of the contract.
But one of the other things that you mentioned is the dealers operating as a creditor. Even under the Uniform Consumer Credit Code, there's creditors that have a different set of requirements, and then there's arrangers of credit. So all the dealers have to file as under a category of arrangers of credit, I believe. It's the notification filing. They're not filing as actual creditors. They're arranging financing, which is a different category of.
For UCCC purposes,
entity.
though.
For UCCC.
Difference between that and truth in lending.
Correct, right.
And dealers do have truth in lending obligations,
Right.
that's true. But they're not finance
They're not
companies, right?
finance,
Well-
they're not
And
lenders.
you stated dealers finance deals, and they don't. They help arrange
Of
finance.
course they do. We're still throw away from a bunch of buy here, pay here lots on Colfax.
Well,
Of course they
and they're-
do.
We're not talking about that. We're not talking about the buy here, pay here situation.
That's a significant portion of the market. I don't know why we're not, but
But you're
to
right,
get
those
back to
are
your
functioning
point.
as creditors.
And where does the distinction lie? I mean, you've got a bunch of car dealers here. Who's never financed a car deal? I mean, it happens. Under the ECOA, which is what you're talking about, there is, and the case is interpreting it, there's a gradient between referring creditors and participating creditors. So, yeah, there could be some people that are referring creditors, and I think that would be a very clean and the way it ought to be done, where you enter into a buyer's order and you say, you know what, now we're gonna go look and see if we can get you financed. We'll call you Tuesday and let you know if we got you financed. And a person doesn't leave with a car, they don't leave with a finance contract. Then you have participating creditors. Now, what's a participating creditor? Well, if you put your name on the finance contract, you may be. It's not a black and white thing. But then you go into other things, like, are you participating in the interest rate? Okay? Are you, do you have, and that's where your industry term participation comes from. Yield spread premium, is there a buy rate and a contract rate? Okay, so dealers can certainly be participating creditors, and I know you all get the industry rags that tell you to send out adverse action notices when you don't get something financed, because better to err on the side of safety that you are a participating creditor. And if you're not a creditor, you have no obligation to do an adverse
Which
action
partly
notice.
goes to how they're defined under that portion of federal law, not necessarily the area that we're talking about under state law though either.
Right.
I mean, that's a very
And
specific
we're
definition
getting-
that triggers the adverse action requirement.
We're so far afield here. I mean, I think, Rick, your position is that every spot delivery is a guaranteed finance deal.
No, not at all.
That's pretty much what you argue when you call me about a new case.
No, every spot delivery is not an automatic finance deal. When you sign a finance contract.
I didn't say automatic, it's a guaranteed finance
It's
deal.
a guaranteed fine when you sign a finance contract. If you look
See,
at
that's
what-
your position, and it's
No, that's the statutory position, and that's how I can argue it, because the statute says guarantee means oral statements or a written document that would lead a reasonable person to a good faith basis to believe they're financed. What would lead you to a more good faith basis to believe you're financed than a finance contract? I mean, you walk out with a finance
That
contract.
says that the seller can cancel if financing is not approved.
Again.
On the back, yeah, I get it. Okay, but see, that the problem is it's not financed with that condition subsequent in it. It's not guaranteed.
It's not there.
So what you're saying is, it's not a condition preceding, it's a condition subsequent. So the consumer can bring the car back if they take it home and say, yeah, the wife doesn't like the color. They can turn around and say, here's your car.
It's only cancelable by the seller.
See?
If financing is
Not
not
approved.
approved, it's a very specific.
No. You got two different things here you're talking about. One is a condition preceding, one is a condition subsequent. Okay? A condition preceding is, you've got a contract unless something happens.
Unless we cancel it because we can't get you
Right.
financed.
Condition subsequent is the opposite. You don't have a contract until something happens. You're saying there's no contract unless we sell it.
No, I'm
which
saying
means
the
consumer can
contract
cancel it.
can be canceled, Rick, if financing's not approved. If you
Then
were-
there's financing.
No, because again, and I'm there with you, Mike, that's the whole point. It's the seller's right to cancel.
Right. Then
And-
cancel
but again,
what?
cancel a retail installment contract. That doesn't mean, again, we have to differentiate. We have two different contracts. We have a retail installment contract, we have a buyer's order.
Well, that's one of the fundamental things of this
We can go and
contract.
cancel the
We need to
retail
find
installment
that.
contract because we can't assign it. That doesn't mean at the end of the day, going back, that potentially the buyer's order doesn't remain in effect, and we don't have our bailment possibilities under the retail, or under the buyer's order.
See, my argument would be you do not have bailment because you had financing until it was canceled. Okay, when you say we can cancel it, what do you say we can cancel? We can cancel the finance contract. right?
Because we can't assign it.
Because we can't.
Right,
That's the whole
right.
thing. It's not because
But
it's because we can't
you
assign it.
have to define whether you got a condition preceding or a condition subsequent. If you're saying this contract is not binding until we get financing, okay, then there's nothing to cancel.
How's it any different than a real estate contract where I say, until I've had an inspection and it goes ahead and meets all the the requirements of the inspection, I don't have to buy it.
No, it's a real estate law.
It's the same thing to me. It's basically still a condition that has to be met before I'm obligated to go ahead and.
Then the consumer can bring it back because either both parties to a contract are bound or neither is bound. If you're saying this contract does not take effect until we get financing, then yes, everyone's got a 3-day, 10-day, however
Until
long
we
it
can
takes to
assign
finance
it.
it.
Not until we can assign it's the difference.
I'm sorry, I missed the first part. Until we can sign it, what?
Okay,
As a
that's-
contract or
assign-
isn't a contract?
Basically, until we can assign this contract to a third-party lender,
Right, it
we
is
have
or
the
it's
right to
not.
go and cancel it.
No. Let's break it down into smaller pieces. Until you can assign it, it is a contract or it is not a contract.
They're not contractually obligated under the statute is the way I would read it.
Who's they?
Either party.
Okay, fine. And if that's the rule, I can live with that. If you can bring the car home and the wife doesn't like the color and bring it back because no one's obligated, great.
But
You don't
from
like
the
that, you
standpoint
can go
of-
down the street?
Of assignment part of it, from the
No,
assignment part.
the assignment's the condition. Now, there is a binding contract until that condition happens, or there is not a binding contract until that condition happens. It's one or the other. Pick one.
Finding until that fails, and if the financing fails, which is the only failure that's really allowed for, so. The
Excuse me?
failure is outlined in the contract.
I'm sorry, but I thought we were here to discuss this form, not the definition of financing. Originally, this form, and let me back up a little bit, I'm a retired supervisor investigator for this division, and I was here for 32 years. I was here when this form was formed. The reason that this form was formed was to determine whether the deal, the transaction with the dealer is cash or financing. Somehow, this form got all muddied up. It was supposed to be a very, very simple form telling us and the world, dealer, you're financing the vehicle, or customer, you're paying the dealer for this vehicle. Okay, this was supposed to be a simple form. This financing argument has to do with the statute regarding deceptive trade practices. We're here to discuss this form. I mean, if you guys are going to sit here and bicker about when financing is final, you're wasting our time. We're looking at this form. We want to make this form valid for the customer, so the customer can say, yes, this was a cash deal, I was going to pay cash, or the dealer was to arrange financing. Back when I was an investigator, it was very difficult for us to figure out, because there was a buyer's order, and it said balance due. Balance due by who? Was the customer going to bring the cash in, or was the dealer going to do financing? That's what this form was initiated and originated.
So at that point, was there a standard retail installment sales contract at all? Was
Back
there a
then.
standard retail installment sales contract that existed at all at that point?
Um,
Or did that come later?
No, they had them back.
Yeah, they had
them
a
back
retail
then.
But they
installment
maybe weren't
contract.
always used, or,
Right, you'd have a buyer's order that would say, balance due.
okay.
And the dealer, the
May or may
customers.
not have a retail installment sales
Yeah.
contract.
You know what,
That's interesting.
well, I shouldn't say this, but there probably was a retail installment contract, but we didn't see it because the customer didn't get a copy of it, but the dealer did.
Okay.
But as far as the state, the customer didn't get a contract, we didn't see it. We needed to make a form. What is it? Is it cash or dealer arranged financing? And if the vehicle is spot delivered and financing cannot be arranged, now's when your discussion comes in about what financing is, and you pay so much per day and so much per mile for the use of the vehicle.
Well, let me, Mary, when it says initialing these, incorporate them into your contract to purchase a vehicle, what was your understanding at that time? Where did it go into? To the buyer's order?
This form?
Yeah, that one, because it says this clearly, it says that's the whole intent, is, my understanding from, and, you know, this was a while ago, is that the whole problem was dealers wanted to charge bailment. There was no ability, because they didn't have it in a buyer's order, to charge bailment, because whether they used the vehicle or they didn't bring it back, we want to be able to say, hey, you know what, you used our vehicle, we want to be able to make some money from that. So that's why kind of the D&E were put together. So is that your understanding that went into the buyer's order? And maybe it's because nobody was using retail installment contracts at that point. That could have been the whole premise, that they weren't using them. So dealers, we're now gonna, as the state is, we're gonna protect you and allow you to go ahead and take down payment money, in essence.
Okay, there's a couple of questions there. Was this a separate form? Did we always think this was a separate form? Yes, because the statute says that the board is authorized and empowered to prescribe a form or forms to be used other than the retail installment agreement, to have all these terms on there.
Right.
Okay, was the bailment added on after the fact? Yeah, when the division is into rulemaking and they were adding the contract is for cash or for financing, the stakeholders meeting, which would be the dealers, say, well, at this time, let's enter the bailment agreement. And that's when it was agreed upon. If financing could not be arranged, and that's your argument there, then they would pay so much per day and so much per mile. And back then, it was 3 days, and it went to 7 days, then it went away, and now it's back to 10 days. So, that was just my opinion of the form.
The statute-
I was there, I saw it.
The statute, 118 specifically permits you to put it in your buyer's order, Mike. You just gotta do it in a particular.
You gotta do it in the sequence, and that's.
Well,
the
and
thing.
it's gotta be initial, and it's gotta be a particular type size.
Right, and
So,
so-
I don't even know why that's a discussion today. I mean, the statute specifically permits it, and if you want to advise your clients to do that, you're free to do it.
But I guess the question is, why do you even, and let's go back to, and, you know, Rick's point is, okay, and Bruce brought up, okay, guaranteed financing. Rick has always brought this argument that, hey, you give them a temporary permit, that the sale's consummated, so therefore you have to have guaranteed financing with a creditor, blah, blah, blah. Let's take it from the reverse back, is, okay, that's one part that collectively do we want to go ahead and clean up. I think that part needs to be cleaned up. I think consummation of sale is a terrible word for the temporary permit. I think the fact that the statute uses consummation, non-consummation are terrible words. I'm more saying, first of all, get rid of the form, because specifically the regulation said if you've got the retail installment contract, you don't use the form. The form to me is useless, has been useless, and has only created more problems in the last probably 10 years because of the conditional nature of retail installment contracts than it solved.
I actually pretty much halfway agree with you on that, Mike. I think the fundamental problem is the disclosure form doesn't define what a contract is. And so my position is, Mike, you can roll your eyes and shake your head all you want. It
Everybody
specifically
knows the
says,
contract, Rick. I mean, how, is this gonna be 20 pages, because we're gonna define every term in it? I mean, that's a waste of
I
time.
think if you're gonna incorporate something into a contract, at the very least you want to define what a contract is, right? And the statute specifically excludes retail installment contracts. So the bailment agreement ties into the buyer's order, and I think historically, you know, that seems to be what the process was. Mike, I kind of agree with you. I mean, unless you're gonna define what the contract is, and if this becomes an addendum to or incorporated with, it becomes incorporated with the buyer's order. And yeah, you can put all that stuff in the buyer's order. I mean, I certainly agree with that. Unfortunately, I think the regulations say you have to use this form. There's a conflict in the regulation that because it says it permits the executive directors to prescribe these forms, and then, you know, sub 3, the use of this contract shall be mandatory in the sale of every form. So there's an inherent conflict.
And actually, I would kind of agree with you on that, because last time this was changed, there was language that was more clear that it could, these provisions could be put in other contracts, and that language was dropped. And at that point, I think it became really unclear whether these provisions could be incorporated in other contracts or not. So I would agree with you on that one. And I still find the very, again, this goes to the statutes under which all of this falls and what do they mean, but that very first part about a form to be used as part of a contract for the sale other than a retail installment sales contract subject to the provisions of the UCC, like, what does that mean? I still don't know what that provision means. I mean, it almost excludes, it almost says that these provisions don't apply for a transaction that's governed by the UCCC, which doesn't make any sense.
Well, that would correspond to why they put at the top of the disclosure that unless you've been given a fully executed retail installment contract, you don't use this form. I mean, that was, I think, the thought process to say, look, under Truth in Lending Act, technically, you fill out a retail installment, I mean, and again, I'm not agreeing, but that's, I think, where you're going is, you fill out a retail installment contract, at that point, these other ancillary provisions that are going into the buyer's order really are not gonna make any difference. That was their thought process. Do I agree with it? No, I think the nature, again, because of how we have inherently grown as an industry, that lender approval, assignment of contract is, we're gonna disagree, is the condition upon which the retail installment contract stands. I think we need to go ahead and bring back in the very fact of whether we need the form, and how do we get away from his argument of, you have a consummation of sale, and you have guaranteed financing. I think every dealer in here is saying, no, we're not guaranteeing financing. We know it's conditioned upon, we don't want to hold the paper, but we have to get away from what has been historically the temporary permit, and even this part of the statute.
But what we need too is clarity for the consumer. You guys can't even all agree on what's a contract, or when financing is approved and when it isn't, and all that stuff. They walk in, and I've got to speak from like the perspective of my 76-year-old mother. She comes in, she says, "We finance everyone," painted on the side of the building. They sell her a car, they toss her the keys, they put a temporary permit on the back of it. She doesn't have a clue that she isn't financed yet. She really doesn't. I got to be honest with you. You guys are all savvy business people. You do this 40 hours a week. My mom buys a car once every 15 years. She's not that savvy. We've got to help them too in this. We've got to have clarity for them.
I'm going to take a break. She said exactly what I was going to say in a much more elegant way. Y'all argued this debated this very well. You're all very sophisticated. Put yourself in the shoes of a consumer. And I'm sorry, but new car dealers and used car dealers look at this issue a little bit differently too.
Bruce,
Because of buy here, pay here.
Can I
Okay?
tell you from firsthand experience, I went with my son to one of our mutual clients, new car dealer, sat in front of the GSM. He said, my son's got a 590 credit score, he's 25 years old, makes $2,200 a month. He said, I got you at 7.99%. 1,000 down, $500 trade.
You got my number, right?
2 weeks later, I get the call. It's 14.99%, we gotta put another 1,000 down. And I said to him, I said, if you weren't my client, trust me, we'd be having a problem. I'm sorry, I know it, we all know it happens out there. That's where I agree. I saw it firsthand. I haven't been that pissed in a long time.
And we get those calls all the time too, and I'm not dismissing any of that, but all of this is governed by what the statutes currently say, so that matters in this discussion, and I think the key is transparency, but even right now, pretty much all the contracts have a clear disclosure. I mean, this form has a very clear disclosure, and people still don't often realize it.
See,
I mean, I get those calls too, but.
See, that would make me say it's
but
not
even
clear.
having a separate form doesn't do the trick.
Is it disclosure because attorneys understand it, or is it disclosure because the average consumer does not understand it? I guess that's the argument.
Precisely.
And again, I do think a lot of people don't understand.
Yeah.
It's just, even when you have a separate standard disclosure form that everybody signs, it still often isn't.
You gotta make it as clear as you can. You're never gonna get 100% of the people to understand
They don't read
100%.
everything.
It's never gonna happen, which keeps.
Yes.
My
doing
goal
business.
is, I'm sorry, John, I interrupted.
No, no, no.
My
Which I think
apologies.
goes back to the moral guarantee, right? That's why they put that in.
Can we get to a point, that's what this group mission is, can we get to a point that we do protect the dealer? The division's position is dealers are entitled to bailment under certain conditions. You got a consumer that lies about their, okay? Absolutely, okay? You got a consumer that brings back a car and it's trashed,
Or won't bring it back for.
or won't bring, those, but when the bottom line is, when you put a temporary tag on it, and when you give the keys, And I don't care if it's written or oral. When that person walks out the door, legally I understand. When that person walks out the door, that unsophisticated person walks out the door, average citizen who doesn't understand all the legal mumbo jumbo, they think they bought a car and they think they're financed. That's the bottom line.
Well, I can't control what people think, but I can control what contracts they
Well,
sign, Bruce.
I understand that, Mr. Donald, but the issue is this. Can we do something that protects both sides of this?
And makes it clear.
And makes it clear. That's the whole thing.
That shouldn't be that difficult.
Here's what I hear from the industry all the time. We want clarity. I do too. And I guarantee you, the people that call in, they want clarity too, and they don't have it. That's the issue. Can we have clarity in this by doing something different than what we're doing?
And I would suggest that nothing we're gonna put in this form is gonna make people read and understand the contracts they sign. So there are always gonna be those consumers out there that leave the dealership with the misunderstanding that they are financed.
There's a fix to this. I always say it, and I'll say it on the record.
Which is to outlaw spot delivery.
Don't allow spot delivery.
Legislature to do it.
I understand, but if we don't allow spot delivery, then this issue totally goes away.
Well, and you also have to realize that people want to leave with their car, and 90% of the time, financing is going to go through. Whatever that statistic is, I'm sure we could get it somewhere. The vast majority of these go through, and if I went to buy a car and I was ready to pull the trigger, I am mad if I have to wait a week to come pick up my car. And so you're going to make everyone wait for their car because a small subset don't understand or realize what's going on. I mean, to me, that goes back to the balancing act here. And I think we have to be transparent. We have to try to have very clear disclosures, make them as clear as possible. But again, you have to balance that too. I mean, there is a consumer constituency on the other side too that wants to take their car home, and their financing is going to go through just fine. And they're going to pay a penalty because of the others whose credit is bad and falls through, or something else goes wrong.
I'm not really advocating for doing away with spot delivery. I know it probably will never happen in college. But nobody tell me it doesn't work because other states do it. And it has worked in those states. And it hasn't shut down the industry. It does work in those states. Okay?
Very small number of states.
There is a very few number, that's true. And I agree with you, Tammy, they want to go home with the car, I understand that. But I sat right, John Shinden was sitting right in that chair when he was on the board, and Deb Thompson was sitting right there, and we had this discussion last time, and we talked about the finance guy filling out all the stuff after he looked at all the paperwork, and he has the client there, the consumer there, and she turned to him and she said, John, if your finance guy doesn't know that this person can get financed or not financed within 1 hour, you should fire that person. That's what she told John. Remember that conversation? These finance people know. And in your case, Mr. McKinnon, the finance guy for your son, come on. Come on.
Bruce, I'll send you the GM financial contract I just read this week for a GM dealer. And what it says is GM Financial will give you preliminary approval when you send everything over to them on the internet. They have the right within 30 days to revoke that approval. That's the world the dealer lives in.
But that's a separate issue. I mean, that's a separate contract. That's between you and GM, right? Consumer has absolutely nothing to do with what kind of deal you've got with GM.
It has everything to do with it.
The consumer has
GM's
absolutely
buying
no
it.
input to it whatsoever, and if you can't negotiate better terms with GM, Ally, or whoever they're doing these days, that's not on the consumer's plate.
GM's
So if
buying the contract, Rick. It
then
has
sell it to
everything
someone
to do
else.
with it.
Are you saying GM's the only game in town?
Absolutely not. There's multiple finance
Great,
companies.
fine. Negotiate some other terms.
They will be the only deal in town on leases starting this next year as far as getting assistance from the factory. They're gonna only give the assistance to GMAC contracts.
Really?
It's brand new.
Wow.
10-minute break.
Wow.
Hold your thoughts, 10-minute break, come back at 20 after. I appreciate, great discussion. I appreciate the professionalism going back and forth. I I understand, there's different sides to this. Appreciate the professionalism, okay? Thank you. 20 after.
I don't want to mess it up, so if you want to pause it so it's not recording the break, then I'll let you handle that.
I know how to pause this one, actually.
I don't care.
No, it's the way the statute.
See, I don't know if you
Does that say
literally hit
pause?
stop or if you can just hit pause. See, I didn't want to.
Are these reading glasses?
Yeah, those are my glasses. Feel free. They're dancing.
Maybe I can see something.
I'll ask you later. Maybe I can ask you.
Mess it up. If there's a way to mess it up, I'll find it.
How'd you do it, Jerry?
It's just the back.
Real problems.
Okay, let's get started. I think everybody's back. For the purposes of the record, we're back on the record, and it's 10:22 a.m. Where we left the discussion off, I think Mr. Perkins had, I don't know if you remember what, but you had a comment that you were ready to make.
Yeah, Steve Perkins, and a used motor vehicle dealer, also former member of the board. There's going to be job security for lots of you in the room. Congratulations. You know, at the end of the day, I agree with Mary, is there a way to improve the form to help better protect dealers and consumers? That I think is our charge here today. Whether or not how they're legal, I will say as a prior member of the board, and when the board hears these kinds of transactions, I think they're bound to rule based on how it's been done in the past, unless, and I'm not an attorney, I'm a car salesman, unless there's a statutory change that clarifies or changes what historically has happened with the board. So I think that we just have to look at improving this form and this disclosure, hopefully making it more transparent to a consumer, and hope that they read it. This form was modified while I was on the board under the sunset in 2007 to include the information regarding the auto industry division. We were charged to put information in front of consumers that this division was out there to help them out. So that was modified at that time to include that. You know, I know that there was a discussion. I don't think we as dealers do know if there's financing, right? Yeah, do we have a good idea? But I see people get approved all the time that I would not think get approved. And I see people where we submit them to 4 or 5 banks, and they're approved from 5 to 15%. And the very next day, what looks to be the same set of circumstances, somebody wouldn't be approved, or in reverse order, right? We certainly have a charge out there with the CFPB today, but when you look at a borrower under a single set of circumstances, and 4 different banks will approve that with a 10 percentage point swing, and that happens a lot. But I think at the end of the day, the form can be improved that will provide what the division needs and what consumers need and what dealers need.
Thank you, Mr. Perkins. Great memory about when the last revision to the form was made. That's a great memory, because you are 100% correct.
I'm
Absolutely.
old, but
Pick up the discussion from where it left off.
I second Chris's and Steve's comments about simplifying it. I think the consumer needs a simple form that meets the requirements of 118, unless we're gonna go for a statutory amendment, and I don't think that's what we're doing. Meets the simple requirements of 118 and explains the spot delivery process. And that part about explaining the spot delivery process is gonna be the hard part, because we don't all agree on what's involved there. But I think A, B, and C are really pretty much straightforward, dictated by the statutes. It's really the spot delivery piece of this form that's gonna be the hard part.
E.
E,
in the-
oh yeah, where you can file your complaint.
No, E in the form. A, B, and C is, A, B, C, and D in the form are, I mean, if we stick with the form format, is anybody have any problems with A, B, C, and D? I don't know that we have necessarily.
Matt Heap, Auto Industry, E is the problem. It just is.
Yeah.
And regardless of what everybody wants to argue, who thinks unguaranteed at what point, it's in the mind of the buyer. The statute defines it's in the mind of the buyer when guarantee happens. So whether or not you guys as dealers say, I'm not guaranteeing them financing, is a moot point. It's what's in the mind of the buyer. And whether we keep the form or we get rid of the form, it still does not allow for you to take down payment or deposit, which the other problem is, those are interchangeably used, those terms, and they're not the same.
Two different things.
Two different things, but they are interchangeably used, and we see it all the time. 61708 says they can't sign a waiver allowing for you to take this deposit or down payment or whatever terms on the buyer's order. So whether the form exists or not, you can't do that stuff anyway. And I think that's the crux of it, is the term guaranteed.
Matt, what if your contract says that the seller does not guarantee financing?
I think the problem, you have to convey and be able to show that in the mind of the buyer, they truly don't think, reasonable buyer, that they really don't think I'm guaranteed. And I think the problem that you have, and we've gone back to this already, is when you give them the keys of the car in a registration document, which is what a temp tag is, and hey, that's an oral representation, have a great time with your new car, congratulations. How is that not in the reasonable mind? I'm guaranteed.
Because your contract says the seller does not.
Yeah, but the statute says oral.
And you initialed a provision specifically stating that.
But some of the provisions, E for instance,
And I agree.
it flies in
wording
the
is
face
confusing.
of statute.
See,
And
There's
I
stuff
agree, it
in
needs to be
E that
cleaned
you
up.
can't do per 61708.
See, and where I fundamentally disagree with you, Matt, is on the guarantee. You say every car deal where there's spot delivery is guaranteed.
No.
You've totally bought into Mr. Winkoop's argument.
No,
and I
I'm
couldn't
saying
disagree
the
with you more.
statute says guarantee is defined statutorily.
Right.
And that is in the mind of the buyer.
So in every spot delivery, then there's a guarantee of financing.
If a reasonable consumer thinks that I am guaranteed, that's all that does that not what the definition says? I mean, by the attorneys in the room?
That's what it says.
Isn't that what it
But I would
says?
say that is our fundamental point of disagreement.
Right, no,
And the
and I
fundamental
agree,
point of ambiguity.
but that's our problem
that
from an
needs to be
enforcement
fleshed out.
standpoint.
Yeah, I agree. I agree.
Because this form is allowing for you to do certain things that 61708 forbids.
But see, 61708 only happens if there is that guarantee.
In the
consumer's
mind of the buyer.
That's where the
And
guarantee
what you're saying is
happens.
every consumer has that in their mind.
I can't get in every consumer's mind, but what I can tell you is the statute defines guarantee, does it not?
It does, clearly. It clearly does.
That when they come
But
to you
that
and they say,
definition is subject to a lot of
when they come to you and say, hey,
interpretation.
Matt, they threw me the keys, they gave me a temporary tag, I thought I bought the car. Most of the time, you're gonna say, I think is that how you rationalize it, say, that would be a reasonable person saying they thought they're guaranteed.
In a lot of instances, when we investigate these cases, we end up not getting right to the heart of the matter because of the conflict that we have on this form.
So how would you?
And a lot of the times they end up going
make it clear?
civilly
How
in
do you
this
make it-
instance, and there are several civil cases out there that we could probably go research that lean towards the assertion that if you have the temp tag and all this other stuff, that a reasonable person should believe they're guaranteed financing.
So let me ask you this, is there any set of objective criteria that we can come up with to make that more clear? Or do you
On this
think-
form?
Yeah, or a
Well, I think there's
form,
parts
or
of
just-
E that just needs to be flat out removed.
Last two sentences.
Yeah.
I don't know where the last two sentences come from. We can
And-
keep your down payment to pay for,
No.
if someone's got a claim for damages or whatever, there are courts, go sue them. I
Yeah.
mean, your
So
car's
what if
damaged.
the
I mean,
dealer,
it's not ever-
but what if the dealer starts requiring a deposit? I mean, a dealer needs to have some protection. I mean, in the case where a dealer in good faith believes a consumer can be financed, something happens and it falls through. And I've had plenty of those cases where I'm calling this customer, they won't bring the car back, what do I do next? And so those cases happen too, and the dealer is not gonna be able to collect, so what if they ask for a deposit? Can they?
But that's the problem right there.
Well-
This last couple of sentences on E was written in as a convenience for the dealers because they would already have cash in hand and they wouldn't have to go after them separately in a civil
What's
action.
wrong with that, though?
61708 says you can't do it.
61708.
Well,
there's a
under your
guarantee.
interpretation though, and that's where we get
Right.
to.
Here, let me just make this point, and
Yeah.
we can argue this point back and forth. Here's this the point I'm gonna make. We have debate between you and Mr. Domowitz, Mr. McKinnon, and Mr. Weinkoop, totally different sides on this issue. When we put this out last time, we had, don't hold me to the exactness, but pretty close, over 30 attorneys that came back in agreement with Mr. Weinkoop's position. 30 attorneys in this state that said you can't keep the down payment. You can charge bailment, you could charge bailment, but you can't, you refund the down payment, and bailment is, if you want to charge bailment, then bailment is a civil matter.
Well, that's, I mean, was that all plaintiff's attorneys? Was that representative of lots of attorneys? I mean, I don't know.
I'm just telling you when we put it out. I don't know. I'm
Those are
just
the
telling
people
you.
that responded.
Those are the people that will fill
We didn't
those
ask
chairs.
them.
What if your purchase agreement says seller does not guarantee financing, these big bold letters on the face of the contract, and then says, we reserve the right to offset your down payment against bailment? What if your contract gives that dealer the right to do
You
that?
can't, I don't think you can do that. I don't think you can ask for them to sign a waiver that 61708 says, even if you've signed a waiver, it's not.
But it's
I know
not a
why you would
waiver.
want
It's
that.
an agreement that the consumer's acknowledging that the dealer's not guaranteeing financing.
But somebody in the room here that's an attorney, correct me if I'm wrong, but doesn't paragraph 2 in 61708 say you can't ask for them to sign a document to waive that right?
I mean, the problem is, yeah, you can.
I understand
say
why
not
you want to do
guaranteed.
it. Totally.
And I do it. And
I
every
know,
buyer's
the
gonna
whole
write
industry
it.
does it.
And so when that happens, Matt, and the consumer says, well, I thought I was financed, and the plain language of the contract contradicts that understanding, where do you go with that?
Because there's a separate finance contract. I mean, that's all well and good, and that's how it should work. Where you do a buyer's order, and that buyer's order says, you're not financed, we're gonna try to arrange you financing, this and the other thing. But then when you take the next step of signing someone up on a risk, well, you have guaranteed financing. You have.
I disagree with you on that point.
Well, I mean, that's
The
fine, you
contract
disagree,
has
but the
reasons to the
contract,
contrary.
you're financed with a condition that the contract can be canceled, but you are financed. All right? Whether the dealer chooses to exercise that condition is an entirely different thing. What if a dealer chooses to use something other than Rocky Mountain Bank note that doesn't have a seller's right to cancel? And I can tell you, there are dealers that are still using that, because I see them every once in a while and I get all excited and do my happy dance. Because there is no standard contract. I mean, there are contracts that the industry groups recommend, but dealers are free to use whatever they want. So a dealer
That's how
can do a
contract-
contract that says, there's no right to cancel.
And the consumer is free to sign it or not sign it.
Absolutely. And when you get contracts that say right above the signature line, this contract cannot be changed except by a written agreement of the parties. There is no cooling off period. I love the no cooling off period provision that some of the dealers are using. That's the contract, all right? And you can have a contract that has a seller's right to cancel. Got no problem with that. But when you on one document say, we're not financing you, and then you enter into a finance contract, you've basically abrogated what you said about not financing you, because you've got a finance contract. That's the best issue. Forget about the temporary
It's being
play.
assigned to a lender, but.
You are the lender. Again, under the Truth in Lending Act, there's only one creditor. The person who makes the Truth in Lending Act disclosures and to whom the contract is initially payable. Everyone else is an assignee. Right? So you can make a condition that this contract, we have a right to cancel and it's conditioned upon us finding an assignee. Right? You can do that, but you've still got a finance contract. So you can't really have it both ways, where you say, we're not financing you, but we are going to assign this finance contract and finance you, and then hope we can go out in the marketplace and find an assignee.
I'm not sure why you can't have it both ways, that's the way it works right now.
No, because
There doesn't have to
contracts
be-
are contracts.
There doesn't have to be mutuality with regard to cancellation, right?
I'm not saying there has to be. You can absolutely have a condition that says, we retain the right to cancel this contract. But you've got a finance contract with a right to cancel. Right? So, I mean, that's what it is. So in the buyer's order, if you say, we're not financing you, but you enter into a finance contract that says, we are financing you subject to a condition, you financed them. So the provision in the buyer's order that says, we're not financing you is now no longer in effect correct, it's wrong, because you did
I mean, I think we
finance
just
it.
have to agree to disagree on, the legal interpretation here. So,
Yeah.
What-
I think
let-
the fundamental crux of all this is what does guarantee financing mean? And that even triggers point 2 that you're looking at, Matt. I mean, that all hinges on what is guaranteeing financing. So I think that is somehow what we have to flesh out or provide a form that we all agree
We have to
is
make the
enough
regulation
to say
conform with
that
the
it's not
statute.
guaranteed.
We have to make the regulation conform with the statute.
Right.
And
And
Matt, are
the
you
statute is
suggesting
subject to
that this
interpretation because we both have different interpretations right now.
Yeah, I mean, I think it's a matter of interpretation. I don't know when this form was first, 20 years ago?
At least,
You know, there's prior AGs that says that this form and regulation does comport with the statute. And dealers have relied upon that.
Oh, there's no
And-
doubt. We're putting this form out saying you can do it. I mean, but I think that's the problem.
your form.
But we're
yeah.
saying you have to do it. It says disclosures required as part of a motor vehicle sales
And
contract.
so dealers have relied on the division, the board, and the AG's office that this form is required and it stands up to law.
And the problem is, it's been misused, because if you look at the initial instructions.
And I can't help whether it's been I mean, I understand it can be misused, but until there is something that clarifies that,
Which is what this is
that's
about.
why we're here.
Yeah, I agree.
So can we focus on do we think we can improve this in a way that it overcomes the presumption that the consumer is going to believe that it was guaranteed? I mean, do we think we can do that?
Well, yeah.
I mean, I do. I mean, I think even some things like right now, it's all one big blob of text, right? There's not even a heading, right, that says important, if financed, not final. I mean, something in big bold letters that makes it very clear could help with transparency of this form.
Steve, you can say.
Is the AG's office of the opinion that this form is in compliance with statute? It has been in the past. Now, maybe something's changed, but certainly in the past, it has been, or it wouldn't be there.
I'm not gonna make that statement on the record right now. I'm walking into this room sort of very green, and this conversation that we're having right now is frankly surprising to me. YE may be more familiar with it, but I think there are a lot of important issues here. To say it's not valid, I'm not gonna say that obviously either. I mean, this is something that's being provided by the agency, but
Right.
to say that my new Attorney General who just took office today is not gonna have a different opinion is not something
They haven't weighed in
I'm
on it
willing to
yet?
do. Yeah, I think that would be
Around?
unfair
Did
to
you call
her,
her?
unfair to the. Now that I might do. Help. But yeah, I mean, there obviously is a presumption, of course, it's been around for a while. But as you know, you don't have to be a lawyer to know that if the law has been interpreted one way and the Supreme Court says you're wrong, then, you can have a couple of 100 years of jurisprudence go down the drain. So, I'm not ready to take that
Yeah.
position on either way, but I appreciate the question. I totally understand why you'd ask it.
Let me update you a little bit on.
Was that lawyerly enough for you?
Let me
Start
up-
with it depends.
It depends. I could have saved all your.
Let me update you just a little bit on that question, Steve. I asked for an informal opinion 4 years ago, 5 years ago, and the informal opinion is confidential because it's an informal opinion. It's an informal opinion, number one, and it's confidential between the division and the Attorney General's the Attorney General's office, a single attorney who may have vetted it through another couple of attorneys. It is not a formal opinion. It hasn't gone upstairs, so to speak, which would be their language. He came back and said he doesn't necessarily think that the form is in conflict with the statute, but boom, 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 boom. And it's the but stuff, okay? It's one attorney's opinion at the Attorney General's office. So that's, the but stuff is exactly what the division deals with on this issue all the time. It's the but stuff. So can we have clarity? Now, the question I have is, it was pointed out to me that the attorneys in the room, and I'm glad they've done this. This is not, have argued concepts of law that are opinions, okay, in the abstract. That's what attorneys do. That's and that's fine. The question I have for the attorneys in the room, and I should know the answer to this question. I think I do know the answer to this question in the past, but I can't remember. Has there been any court cases around this issue, whether or not they're county court cases, civil court cases, district court cases? I'm sure there's not something from the Court of Appeals on this issue. I mean, I think, Rick, you have argued this case in this in civil court, whether or not the specifics of this, is that correct or not? The specifics of sort of this discussion about guarantee, not guarantee, those kinds of things.
Yeah, I mean, it's all a question of facts, so you're not gonna have a judge weigh in on whether someone had a reasonable.
Well, and isn't it I mean, again, from you guys, you don't, whether you have to look at public impact or not under CCPA, your case have in a lot of ways been the public impact part.
That's the big part.
a crux for the civil part of it. The regulatory part, that's a whole different, avenue for you guys to take. So, I know of your case, I know the cases we've had, it's always been, okay, is there public impact, so I don't have to get to sometimes this guarantee or this other stuff.
Right, and whether there's guarantee or not is always gonna be a question of fact. So you're not gonna have a judge weigh in on, I mean, I guess theoretically you could say as a matter of law, there is no way this is a guarantee. But the way the statute's written is, in a good faith belief that, financing is certain. That's always gonna be a question of fact for the jury, so there's not gonna be a legal opinion on that. Going back to your point earlier, the form may or may not be fine. I mean, there could be issues. I think that the problem is more the application of the form. Because then you got the little preamble here, it talks about, this is required unless the consumer's already been given a copy of the completed retail installment sales contract. My position is, once you enter into a retail installment sales contract, a lot of this, the Section E, kind of goes by the wayside. There really isn't an argument there. A, B, and C, yeah, that's all pretty straightforward. But once you combine this with the retail installment contract, that's where you run into problems.
Okay, and I would, just real quick, and I've always said that first part needs to be taken out completely. I think, again, you take out that first sentence, then you read. Well, again, no.
I agree
What
with
it says, it says it's not part of the regulation. It says sales in which retail installment contract with all disclosures, you don't have to use it. But again, this was something I don't think has to be in the form. I don't think it says, by the way, in the statute, it has to say, by the way, you.
And it doesn't have to be.
So you take that out, because I think that creates part of it. Then it incorporates into the buyer's order, and then I think you rearrange E to say, and again, Matt, I could argue somewhere else and say, hey, guarantee the way, CADA, let's go, everybody go change the definition of guarantee. I mean, there's a reason that the legislature came up with it. So let's come back down and apply, say right now, currently, this is the definition of guarantee, or rearrange E so that we can get to the point and say, look, understand here, you're beginning a vehicle, you're driving a vehicle before the contract's been assigned, we're not guaranteeing any financing, we're not making any statements that would leave a reasonable person to believe that. That would be more to the point to do.
And I think you're right, and I could envision perhaps a rule that maybe lays out something like the presumption perhaps is that, financing is not guaranteed if the dealer follows XYZ steps, one of which is a form that has all the clarity that we think needs to be in there. And so maybe it's a change of presumption or clarity on the guarantee question that we could put into rule.
Maybe I mean, basically, you can't redefine guarantee, but you could say, for purposes of the board, we find that
clarify it,
guarantee
right.
does not, if you have a buyer's order that says, you are not guaranteed financing, we are attempting to assign this contract, or you have a seller's right to cancel in a retail installment contract. These are the things that, just like, when you look at unfitness of licensing character, unfitness of financial character, you have the regulatory things you can look at. This is just gonna clarify more what this, 61708 is saying for purposes of the board, for them to say, okay, there's no way that this consumer could say, hey, I thought I was guaranteed financing because I read 3 different documents that says I'm not guaranteed financing. I was told that, they have to sign the contract. There's all these other things. That might be one avenue to go.
Of course, the other question is that it's not a provision that falls under the dealer board.
Well, you
So-
could go within the 10-day. You could attach to the
Yeah.
10-day, say that basically, as part of any type of finance, contract, you have, if you want to get around this guaranteed financing part, or for purposes of the board to determine whether there's guaranteed financing, here's a criteria that says that there's not. It's in a buyer's order, it's in a retail installment contract. These other things say it's not.
I think that would be problematic. The board is going to create legal presumptions for the jury. And I'd have to think about that one, but I think that's ultra vires.
You're talking about a regulation. It's no different than they do right now, that they've clarified what is unfitness of licensing character by regulation. We are clarifying, for purposes of the board's determination if there's been a violation, what is a reasonable person would assume. And if you have these type of warnings, by the way, it's not guaranteed.
Or
Okay, I'm
maybe
thinking
it's-
more of a jury trial than.
And I get, you're talking that, and this regulation would help. I mean, that's the whole thing, is you've got the regulation, you can bring your violation of whatever you think it is, but I think the board needs to make that determination as well. The jury can make that determination based upon what the regulation is, and a court can instruct them whether the regulation itself.
Yeah, that's my point. I don't think the board can create a legal presumption that would basically result into a jury instruction.
But again, we're talking about regulatory and civil. This is purely regulatory. Whether a jury can be instructed that way, the board interprets its own statutes, it develops its own regulations. It can interpret 61708, even the guarantee part, for purposes of whether there's a violation of the statute.
Well, it could be stronger and not even just a presumption.
Right, it's not a
It's
presumption.
absent contrary evidence. If the dealer does X, Y, and Z and provides this disclosure that's, whatever font and large print or whatever we decide, then financing was not guaranteed, and make it more objective then and not even make it a presumption. Because if it's a question of fact, the dealer loses, because now they're facing a lawsuit and they're gonna have to settle.
Well, you guys don't always settle.
95+% of the time.
Someone needs to start writing you more checks.
I would imagine. That's why there's no case law on it,
I'm trying.
right? That's just because we always settle.
But even the jury's finding of facts, if you had a half a dozen cases you could pull out and take a look at the jury's finding of facts, in 3 or 4 cases, you could at least get some reasonable guidance, in my opinion, without the judge interpreting or giving you a declaratory judgment on what he or she interprets as the law to specifically mean. Also, I think you'll have trouble with jury instructions on that by simply saying, if the jury instruction is simply, you either believe or not, don't believe that it was in the person's mind, yada, yada. So even if it's that case, you might get it overturned on the jury instructions. It may be inadequate for the jury to be able to reasonably interpret what the court is asking of them. Would you not agree that that is possible?
I would not agree, because
Why?
617, well, I'll tell you, because 61708 states what a guarantee means. There's a definition in the statute. So
that translates into a jury instruction very easily. Guarantee means, and then you have, what the statute says.
But that's the purpose of
But they're
the
gonna
rule,
argue-
is to clarify an ambiguous term in statute.
I don't think there's anything ambiguous in
That's
that.
my point. They're gonna come in and
We
argue.
just had an entire
that that's
dialogue
ambiguous.
with two different opinions on what guarantee means, so I don't see how you say it's clear.
Well, Rick's no different than you keep on arguing that 61708, you don't have public impact because it's not, even though the beginning, the preamble of the dealer section says, to protect the consumer. You've made that argument plenty of times. The judge, one time said, hey, you're right, you don't have to prove public impact. Again, a judge is gonna instruct a jury based upon what they believe is the proper instruction for the jury to have. And whether they want to take into consideration a regulation that the board has adopted, which is saying, by the way, for purposes of how we are looking at this specific document, this is what we find in our investigation or in our determination would lead us to believe that it's not unreasonable.
I have never heard of, and I'm not saying you're wrong, but I've never heard of any administrative board being able to overrule the statute. I mean, the statute is clear. Guarantee
Not
means.
clear.
No, it is.
We just had an entire argument with two different
On what
opinions.
guarantee means? I mean, the statute says guarantee.
Guarantee's not
You're
unclear in the
assuming what
statute.
jury-
Yeah, the statute, I mean, guarantee is pretty much
I mean,
defined in
it's
the statute.
defined.
It's,
How is that
we
unclear?
just had an entire discussion with two different opinions.
No,
about
we
what
had
it
an entire
means.
discussion about the form, not what the meaning of guarantee is.
Yes, we
The
did.
meaning
You
of
have-
guarantee
there's an
is
opinion
defined
on
in the
this-
statute.
There's an opinion on the table that giving someone the keys and letting them drive off de facto is a guarantee of financing, and we don't agree with that opinion. I mean, that is an example of an ambiguity of what guarantee means.
No,
And then
we're-
you get in, so it says an oral or other representation that leads a consumer to a good faith belief.
Congratulations, enjoy your new car, here's your keys is not, what's ambiguous about that?
It's not a guarantee.
It's not a
though.
guarantee of financing.
Not to you guys, but to me as the
Well,
car
what
buyer.
if the sales rep may have told the person right out, you're not guaranteed.
Yeah,
you
right.
know.
That doesn't happen.
Mike's even laughing at that one.
Again, I'm not saying that.
Mr. McKinnon just
I'm
told
not
us that
saying
that didn't
it
happen
doesn't-
last
I'm
week.
not saying that people don't make representations they shouldn't have. I totally agree that happens. But to say that it's always done wrong, I think is not fair either.
But we're not talking about always, as you already said, this is about a tiny, minute little segment of the car sales. That's what this form is about.
Right, I agree, but.
The ones that don't have any issues,
Your
this is.
position is that every spot delivery is a guarantee.
No.
No, I didn't say that.
Yes, you have. You
No.
said congratulations.
I,
here's the
I
key to
used
your
that
new car."
scenario.
That's a guarantee.
If Tammy is right in saying that the salesperson said, now understand, I'm giving you a temp tag, keys, and I want you to enjoy this, but this is not yours. We have not got this solidified, and you need to sign this document understanding that even though we're letting you drive it off the lot, you're doing that without financing.
Stop right there. That's what 24
That's a different-
needs to say.
But that, I agree.
Yeah.
That's what 24
And
needs
that's
to
what,
say right
I
there.
agree.
that's what I'm throwing out to you, is for
Yeah,
purposes
I
of
agree.
the
That in there.
investigation.
Put it in there.
Yeah,
Yeah.
it'd be-
You got my
do it that way.
And
Yeah.
that's,
You need verbiage like that.
I
Okay,
agree.
we agree.
Okay, we agree on one thing. Woohoo, success.
Stop
I'm
right
with
there.
you.
You write that down, that, put it in the form and I'll.
Because
and
when
I'll
somebody
send it
comes
right
to us
now.
with a complaint, with that verbiage in there, that is going to assist in saying, well, look,
Well,
you
I didn't
signed
read
this
it,
saying
Mr.
that
Heath.
you
I
understood.
didn't read it.
read it, right?
I didn't
Okay,
read it.
well, but when
I
it's
was
on
so
there with
happy
their
with-
initials
You
next to
initialed
it,
I agree.
we can say, well, you did sign this acknowledging you are understanding this is not a guarantee of financing. That adds clarity. I
Put it
agree.
down on paper, let's go.
So do we all agree that there needs to be a form?
Or the existing form
Or
with one more line.
a form,
Okay.
this form. We all agree we're gonna start tweaking
wouldn't-
this
I wouldn't create
form
another
to get
form.
clarity. This form to
Yes.
get clarity.
I think that.
We need a starting place here, folks, is what I'm trying to get us.
But that
I
was
do, and I
that's
think,
it.
and I think that form is what establishes that a guarantee was not made.
The problem is using the form with a risk. That's where the entire problem comes from. If you're gonna say you're not financed, but you enter into a finance contract, that's where the contradiction comes from.
And
Well, and I agree, that's your opinion, Rick.
you may have to
But
just make that
I,
argument in.
and that,
litigation.
you'll make that in court, or, I still go back that the division, the board, the rulemaking AG's office, at the time that this form was put in place, that it stood up to statute. And we've relied upon it, us dealers and consumers have relied upon it for 20 years. Now, can it be improved, whether bold type, the language that the division needs so that when a consumer comes in, you can say, I'm all about it. And I think it needs to be a form.
Separate form or this
No,
form?
this form.
This form.
So we're
Yes,
gonna
this
tweak
form.
this form.
We don't need
Yes.
another piece of
No,
paper.
we don't need another piece of paper.
I agree.
You know, there's enough, and that's part of the confusion of the car buying process is
Too many
the
pieces.
voluminous amount of.
The original form talks about using this form unless the customer's been given a retail installment contract. I think it becomes a real simple thing. If you want to enter into a finance contract, you give up your right to bailment. You can spot deliver the car, you can do whatever you want, but once you sign the finance contract, there's no bailment. You want to keep bailment, don't sign a finance contract. Don't trip the car.
So you're saying then, okay, look, if the dealer enters into the retail installment contract, they can cancel
Sure.
the retail installment contract, they just can't get bailment. You
Correct.
okay with that?
Yeah.
And you think that, and your argument's gonna be, that complies completely with truth in lending and with the statute?
I believe so.
Why does the dealer have to give up a
Mike
right
hates
to
agreeing
bail?
with
Well, no, you know what's funny? The funny thing is, and again, I've always said this, and I don't care whether Mike Donner, you thinks you and I are in bed together now, because you always accuse me of that, but I've always said this.
I haven't used those exact words.
If bailment is a profit center for a dealer, they need to get the hell out of the business, because that's a problem.
Yes.
More importantly, if they don't bring it back, yes, you should be able to go ahead and charge them for the use of the vehicle. If they damage the vehicle, you should be able to, that can go into your buyer's order. And that's what we do, that goes into your buyer's order. I have no problem with saying, guess what? If your buyer's order says, and I told this to Bruce, I said, you know, if you put a regulation that says, if your buyer's order says that if they don't bring it back within a certain time period, they damage the vehicle, you can charge them bailment as long as you explain what the bailment is. Great. Otherwise, they bring it back when you tell them, you're not charging bailment, you're not keeping the down payment, and it's done.
Why would you want to put that on another form? Why don't you
You-
just
you-
keep that on this form?
Well, again, now the question becomes is, we're taking this and we're incorporating this into the buyer's order, okay? And his argument is to say, look, you're incorporating this into the buyer's order. If you want to change this, all this E around, that's fine. To say, look, you're not charging bailment, you don't get any bailment if they bring it back when they say that. That's fine, that's not a problem. And the dealer has a right to go ahead and cancel the retail installment contract. You can't get bailment. You're compliant with truth in lending, you're compliant with the statute. That makes a lot of sense to me.
I don't understand why a dealer has to give up a right to withhold a deposit.
Again, if that's a profit center, why does a dealer need a profit center holding money? You're the one, and I'm gonna take just the average, you're the one that decided to go ahead and give them the car.
And the consumer decided to take it. I mean, I
And they
still.
decided to get, but again, this is the thing, if they can't get a finance, you can't assign the contract, and let's just assume for sake of argument, the lender looked at it and says, hey, you know what, I need more down. Then if the customer wants to go and bring the car back, why should you take any of their money? If you call them and
Because
say.
they had the car saved for 10 days.
You decided to give them the car for 10 days.
And it was a new car, and now it's a
You
used
just
car.
Willingly gave it to
It was, it's gonna be, it's a used car the minute it goes over 1,500, you're registered. If they
No,
bring
that's
it back-
actually not true. It's a used car the minute
It's a
it drives off that
temporary
lot.
So.
No.
Yes, it
no.
is.
No, it's 1,500 miles.
Instead of 1,500 miles or basically at this point, because it's not been registered, you can issue a temp tag to it and it's not gonna be a new car. So the problem's gonna be,
Well, anyway,
why
that's
does it
another
need to be a
legal point,
problem? Let it bring the car back. Guess what? You're not out anything at this point. You gave them the car. You were hoping that you could get the contract to sign. You can't get the contract to sign. Why should you take money from these people for them using the car that you were trying to?
Why should you be prohibited from doing so?
How
Or
can you use
withholding
that
it
as
from the
demo
deposit?
miles?
I don't understand.
Because you have to look at it from the consumer's point of view.
1,500 miles, you're talking about the 1,500.
Well,
that
okay,
is
when is it gonna become a used vehicle?
Well, no, wait a minute, Dan.
When's it gonna become a used vehicle?
After
If
you
it's a new
sold
car?
it to somebody else.
No, it's 1,500 miles or when it's titled. I mean, that's the statute.
That's a stat.
This is demo miles,
So
demonstration miles.
Isn't that the gap? When's
If
it-
you sold a car.
So if they bring it back, if they take it out with 10 miles and bring it back with 150 miles, and you cancel the contract, is that still a new vehicle?
No.
Yeah, isn't there a private use clause in there?
Is that still a new vehicle?
I would suggest that it is a used vehicle, although I don't know that when dealers provide, new car dealers today say that.
That's right, it's not, that's the problem. You can still RDR that vehicle. Or someone has-
We
yeah, no,
don't,
that's still-
we
that's
don't
still-
do, we didn't, no, I can't speak for it. We didn't do it until we had approval and done and money, then we NVDR'd it. I mean,
Right.
Right.
So-
And
That's
the
a separate
concept
issue.
that the spot delivery is just for the consumer is wrong. I mean, car dealers want people out of the market. If you say, you know what, I'm gonna take your credit app and I'm gonna shop it around, I'm gonna see what best I can get you, I'll call you Tuesday. Well, you know as well as anyone else, the guy's gonna go down the road to the next guy who's gonna say, yeah, we got you bought, here's the contract, congratulations.
Why is the
Because
consumer
they
gonna go
want
down
them
the
out of
road?
market.
Nobody made that
What's that?
argument.
Why is
Nobody
it-
made that argument.
Why is the consumer gonna go down the road? Because they want the
If
car
they
today.
think they're not financed, and if they think they haven't bought a car, yeah, you keep shopping until you buy something.
Because they
Once you
want it
buy
today.
something, you stop.
There's frankly a benefit for both parties. in this
That's my
instance.
point.
I didn't argue it was just for the benefit of the consumer at all. I don't understand, again, there's benefits to both sides in this. If a customer has the car for 10, 15, 30 days sometimes, and again, there are times when the dealer can't get the consumer to bring the car back.
Right.
I mean, there's cases on the other side
There are
too,
repo
don't get me
companies.
wrong. Right, which is an expensive process too, and it takes time.
$200.
So why shouldn't the dealer, the purpose of a deposit is to protect the merchant selling a good in case there's damage or whatever, right?
But it's
If
called a
you-
down payment on the buy, a down payment goes towards a purchase price.
Right.
A deposit goes for use of a vehicle.
A
Big
deposit.
difference.
Okay,
Big
so
difference. So
whatever you
basically,
wanna call it.
if I
But
call
you
it-
can't interchange those terms.
Yeah, that's
Whatever
right.
you wanna call it, it has to be disclosed up front. But I don't understand why a dealer should have to give up the right to charge for legitimate use of a vehicle, as long as it's
Where
disclosed
does
up
that
front.
right come from?
The
What's that?
statute,
Where does what?
118.
The statute authorizes, but where's the right come from? It's a contractual right. The parties don't have to agree to it.
118 authorizes dealers to do it.
Right, it's authorized.
Okay.
But as far as the right goes, I mean, you know as well as I do, people could say, no, I'm not doing that thing. I just bought a car, I said, no, I mean, you're tripping the car, we're gonna zero that out. I'm not gonna pay any bailment. No one has to do that, it's negotiated. The
Agreed.
board doesn't have a $100 a day, $200 a day, nothing's set in stone. So the number could be zero. I mean, it's all
I
contractual.
totally agree, it all should be subject to negotiation. A dealer can ask for a deposit, a consumer can refuse. A dealer can make the deposit subject to bailment charges if they want, by contractual agreement, as long as it's disclosed. What I'm hearing around the table is the dealer shouldn't be able to do that, and I don't
No,
understand
no,
why.
That's, I
Well,
don't think
why
that's what
would
we're
you,
saying.
why would you make it mandatory in here that you
I
have
didn't
to
say it
charge?
should be
Yeah, you can write
mandatory.
zeros in there, Mike.
But why don't you, why don't you do this,
Put zeros in
put it
there.
put it in the buyer's order, get rid of that part, put it in the buyer's order and say, you know what? If you don't bring it back with one of my client does, if you don't bring it back within 24 hours after we tell you you're not financed, we're gonna charge you $99 a day.
I didn't say
99
anything
cents
should be
a mile.
mandatory, you were saying the dealer shouldn't be able to do it.
No,
and
I'm saying if I let them, if I'm a good dealer and I let them know within 10 days, you're not financed.
Mike, you know most dealers do that already.
If basically at the end of the day, we go ahead and say that I let you know within 10 days, you're not financed, bring the car back, they bring it back that same afternoon, should I be able to charge them bailment? And it's not their fault. The lender said, you know what, no, I need another $1,000 down. And the customer says, I don't want to put another $1,000 down. Should they be able to charge them bailment for that first 9 days that they use the car?
If the contract was clear and they agreed to, yes.
Are we talking about, again, this is incorporated into their buyer's order. What language are you gonna put here?
I mean, I'm not,
Well, here's what
I'm
I
not
wrote.
talking,
I wrote one up. Section G, you and the dealer may agree to a daily and mileage amount for the use of the vehicle from the date of delivery until its return in the event financing cannot be arranged. These charges are not mandatory and the amounts are negotiable. If the contract is canceled, you agree to pay the dealer X dollars per day, X cents a mile for use of the vehicle.
I drafted one too, it's probably more clear than what we have. I mean,
I mean, it
It's
can
up
be
to
done, but I think the fundamental point, and Mike and I are in agreement on this.
I wanted to note there are 2 plaintiffs' attorneys in the room now.
And you know, Mike, you know the nice thing about it?
Oh, maybe 3.
My clients will pay me enough to basically kiss everybody's ass. I'm not gonna do that. So I'm looking for consumers, I'm looking for my clients.
Yeah.
I'm sorry, but I think my clients need to also look at what is gonna create less liability for them. This, to me, creates less liability.
Yeah, I mean, I'm basically cutting my own throat here with this argument, that if they sign a risk, okay, you don't get to keep bailment. Well, guess what, there goes half my caseload, knock yourself out, I'll find something else to do. But that's
and I
exactly
just
what
don't
it is.
understand the
If you,
legitimacy of that.
I'm sorry, you don't understand what?
The legitimacy of why, if you sign a, just because you sign a finance contract, you can't charge bailment. I just don't see that.
Because you have financed the vehicle.
And at the end of the day, that's a policy question, and we can have
Well, I mean,
different
if you want to talk
opinions
about
on it.
policy questions, let's talk about risk allocation. I mean, who's in the better position to absorb this risk of not being financed? The guy who's working down at Home Depot is just trying to buy a truck, or, you know, the $1 million dealership who's taking the risk that he's gonna make money on this deal. I mean, if you want to talk policy, let's talk risk allocation. Who's in the better position to handle the risk that a car can't get financed? The guy who puts his last $1,000 down, and 10 days later, the dealership says, "Oh, I'm sorry, we didn't get your finance, there's your down payment."
Why should the
Now he's
consumer
back
have
on the
free
bus.
use of a car for 30 days?
Because the dealer let him. He didn't go in at gunpoint and take the keys. The car dealer said, "Sign this, I will give you a car."
And he or she
You keep on saying 30 days, but it's 10, it's 10
signed- and
days,
he or she
it's
signed
10
the
days,
contract.
it's 10 days, okay? You need to let them know in 10 days, that's the whole point.
Again, I mean, I would
If-
just
if
say
you let them
that-
know within 10, then it should be
You
an
guys
issue.
want to make the de facto policy decision for what everyone can do. I mean, you can certainly advise your clients to do one thing, but when you set in place a rule or a form, you know, you're allowing things and disallowing things. You're setting the policy. And I'm
Yeah.
just saying, as long as it's clear in the dealer's contract, and we have a clear disclosure that financing's not guaranteed, bailment is negotiable, you know, you don't have to sign any of this, you don't have to take the car off the lot, then it should be up to negotiations between the two parties.
All right.
That's just my position.
5 after 11, I promised that we would take a 10-minute break at the top of the hour. Good discussion. I'm going to cut the discussion off now for 10 minutes. Come back, we'll finish the discussion, finish some discussion, and then we will take the last 10 minutes to look at calendars and see when we can meet again, because obviously we're going to have to meet. I have a couple of suggestions in the next 40 minutes of what we may want to try to do next time, okay? The thing that is crystal clear to me in this debate, and this has been a good debate, and I've just let it go because it's been a very good debate, but what is crystal clear is what the division has been saying for the last 4 years. E is problematic when you look at 61708. That is crystal clear from this discussion, crystal clear. It is, Mike, it's crystal clear, because you can't all agree on it, and there's a million customers out there that don't know what's going
Only
on.
if you buy the argument that every deal is guaranteed.
Well, every deal is guaranteed sometimes, okay? It is. And I'm going to take the position of the average reasonable, and if you want me to load that back room with reasonable customers that will make that argument, I'll load that back room, and I don't want to do
No doubt that it
that.
happens.
Okay?
No
It happens.
doubt that there are deals that are guaranteed.
It happens every single day, and it just happened right here. It just happened. That somebody made an oral representation, "Thank you very much, enjoy your new car. You've just bought a car." That just got done up and down Colfax someplace. I guarantee that, okay? So, my goal is this. Clean up E. If we want to keep the form, great, clean up E. My other goal is, can we get the form out of the regulation and write a regulation of the stuff that needs to be in the form, and not have the form be part of the actual deregulation, okay? We have tons of forms out there that aren't in a regulation, embedded in the regulation. That's a great word. My goal is to get the form unembedded in the regulation, have the wording of what the form must contain, but it's a separate document. That's my goal. Just like the salesperson application. We talk about salesperson application throughout the statute, the regulation, but it's not embedded in a regulation or in the statute.
Just to clarify there, when you say it is a separate document, are you saying that the actual form may not be part of the regulation, but it still must be a separate form than the dealer uses?
That's for our
Right.
discussion, yes, okay?
Correct. Right.
Or part of the buyer's order, which I think the statute allows.
When I would say on that, just quickly,
No, don't shut it off. We're still talking.
You said you would take a break, I cut it off.
oh, sorry.
No.
And you had the great word,
Yeah.
lost.
Oh, my God.
Say it again.
I couldn't remember it probably.
10, okay, we'll come back.
Okay.
Just 10 minutes, come back at 20 after, okay?
That's okay, this backup recording
Yeah.
got it, Arlene, so. The backup one that she's got going. Matt?
There's another 600 rules that we have to do this with.
Is that rule?
Record recording? Okay, so we only have about 25 to 35 minutes. Tammy has asked me, because she has to leave a little bit early, to look at calendars, and lo and behold, because I need it, I can't get to the network. So Wendy is looking at the schedule for this meeting, the schedule for this room. She's going to come back here in a few minutes with this room's available, not next week, the week after that, and the week after that, where we can schedule a second meeting. Okay, so we'll get to that before Ms. McCoy has to leave. Okay. Now, one of the things that came up during the discussions, and one of the things I was going to say before I have some ideas on how we could move this process ahead, I think Mr. Weinkoop has given me a copy of something that he has put together. Ms. McCoy has said that she had put something together or gave a copy to Ms. Scott. What has to happen on that is, can all of you, Rick and Tammy, what I need everybody to do is this, because this is part of, as soon as you hand something in, it's part of the record, okay? And because you're handing in drafts of things, it needs to be shared to everybody in advance of the next meeting. Please, scan a copy in, go back and redo, based on the discussion, what you think how it should look for the next meeting. Scan it in, email it to me. You all have my email address. Email it to me. As soon as I get that, I'll put that draft in the record, and I'll turn around and I'll email it to everybody. Okay? But email it to me first, and I'll turn it around. Okay? Before the next meeting.
Could that be inclusive of Matt's lines that he had just talked about as far as putting into E?
The division can draft some kind of language
that was said
too.
very well also, and I think we generally agree that type of verbiage would be acceptable.
Right.
Then we can play that back in the recording and get it pretty darn close to what he verbalized.
That's why I stopped it.
So
I liked it so much.
let me go back to what I said before. This is my goal. Doesn't mean that we're going to reach it. Doesn't mean that my goal is your goal. Doesn't mean that. Okay. I would like to get the form unembedded. If everybody thinks we still need a form, I have no problem with that. I'd like to get it unembedded. To unembed it, we have to have language in the rule. Okay. Follow what I'm saying? Right now, the rule, if you look at what I sent you, right now, the rule, the regulation 126104-3K disclosure form, the form is the rule. There's no language before this, and there's no language after it. So if we're going to keep a regulation 126104-3K disclosure requirements, we have to draft what those requirements are. And then we can say that the board will adopt a form. That's really all we have to say. It's no different than an application or any other things that the board does. Okay. Knowing that, I think Mr. McKinnon's position is, and I think the Attorney General's office last time agreed with his position, is that the statute would allow these types of disclosures to be incorporated into the contract. Buyer's order. And that's what you have done with one or two of your clients. I think that is still, I mean, the statute's going to allow that, okay? So what I think we're looking for the next meeting, go back, take a deep breath, throw a rock. This has been a great discussion. We'll continue discussion, okay? But draft something if you think you've got it. You think you got something that you think you want to push forward, draft it, send it to me. I'll make it part of the record and turn it around. I'll turn that around almost immediately before the next meeting. Okay, well before the next meeting. Okay, so you have a chance to see what other people's words are. Now, what I would like to do, I mean, what I heard in the agreement is, what I heard that I think there's consensus on is E is problematic and needs reworded in some form if we keep that. I think there's consensus on that. Okay? I know there's not consensus on other issues, but I think there's consensus on that. Now here's the other issue that we can spend the last few minutes of this talking about. let me throw this out and then let's look at the calendar. But when we get to E, it also talks about financing terms, interest rates and so on and so forth, okay? We have had tremendous debate on whether or not what's put under this form, if we leave that into E in some way, what's put into there as far as an interest rate, because a lot of places just put 21%, yet their retail installment contract says 9.9. That is very confusing to consumers.
That's in D.
Is that in D? Okay. That's very, now I think that the board, when we attempted this last time, took a position, not in rule, but took a position that those two may need to be consistent. Is that, do you remember that, John? That I think that those. There was dialogue, and I don't know, there was never a motion or anything, but I think there was consensus, not, I don't know what the word consensus means 100%, I don't know, but there was a lot of dialogue on whether those two needed to be consistent. Then we get into the issue of the other two regulations that the sister regulations, power sports, that we talk about, and that's the rejection of the financing, how that, and whether or not 10 days is long enough, is it too long? I think there was a lot of debate that 10 days is not long enough. There was a lot of debate that 10 days is way, I mean, you know in 2 or 3 days, or otherwise, you know within a few hours, otherwise fire your finance guy. I mean, that's what Deb said. So that's still open for debate in this context. Because I gotta tell you, in my opinion, well, it's within Group 1, Priority 1, and they sort of need to, we need to discuss both of the issues at the same time and see where we want to go with that on the issue of, what is that, V?
Yes. Yes.
Okay. Before I get to that, does everybody have their calendar in front of them? Okay. I am looking at the week of, starting this month, January the 26th. And I would look at January, the week of January 26th, the week of February 2nd, or the week of February 9th. Not next week. The second week or the third week is what I'd like to look at, because I just don't want to, I want to keep this fresh on everybody's mind. There are 13 or 14 people here together. To get all 13 and 14 people to agree on this is going to be difficult, but that's my goal. Try to dedicate some time. 9 to noon or 1 to 4, okay? We're never going to agree. I hope you have some wiggle room in your schedule. It looks like this room is available. Actually, the first thing I would tell you is this room is available on Thursday the 29th, because we already have it reserved and we're not going to use that. That's a motor
That is
vehicle
correct.
dealer board
Secondary
meeting, and we're not going to use that date. Look at, look at Thursday, 1/29, Thursday, January 29th.
The only thing we have is with,
You got a meeting with me,
What time is our meeting?
10:30.
Stipulation meeting?
Yeah, we can.
Can we bump it into the
Bump it
afternoon?
into the afternoon or vice versa, yeah.
Sure. I can call the client and find out. I don't think it'll be a problem. It's not a problem with me, so. I just don't know how much time you want to spend with me.
And then you can spend the whole darn day here.
Wow.
It's always a pleasure.
Thanks, Bruce.
I will not be here, but
I would love to go afternoon.
we'll let you
Send the new Attorney General.
to the new one.
Tammy's not a place.
Okay, first of all, is everybody's calendar available for some time that day?
Except me.
I have jury duty.
Well, that's a good excuse.
I hope it's a
to
spot delivery case.
I hope it's not Holmes.
Boy, I do.
Jefferson County, thank
Okay.
God.
Get a letter from Bruce.
I should carry some weight.
So you'll be excused.
You'll be out fairly quickly.
Okay, so Mary,
Yeah, they'll bump you off early.
Mary has a conflict. Anybody else have a conflict on that day? Now, if we stick with that day and say Mary can send information in, you could obviously listen to the recording, those kinds of
Or may
things.
not be called.
Or may not be called, is,
Because she's got to listen to the recording the night before to see if her number rolled up
Yeah.
and if she
Is-
really has to show up.
I don't want to go over like 3 hours on these meetings. I think we get brain dead after that. We could do, and I know that Tammy has expressed interest that 9 o'clock's a little too early, and the person sitting to my right is.
You gotta be kidding.
So, would 10 to 1 be available? Just take lunch after 1 o'clock. Would 10 to 1? Then you and I will have to reschedule sometime 2:30-ish, something like that. Would that, okay?
Would you rather go later and then you guys can still have your meeting, or, no?
Well, why don't we start at 7?
I don't have a problem with scheduling this meeting at 1:30. 1:30.
Now, if we do 1:30, then Mary may be excused even if she has to go in the morning.
Do 1 to 4.
Yeah, do 1 to 4, because they'll dump Mary. They're not going to pick her to be on that jury.
1 to 4?
Works for me.
1 to 4?
All right, so we're going to do 1 to 4 is the next meeting. I'll send out a calendar invite.
The 29th.
So you'll get a Google Calendar invite, because we love Google at the Department of Revenue. You'll get a Google Calendar invite, 1 to 4. So what I would like you to do is start funneling me any suggestions you have, and I will turn those around between now and certainly no later than Tuesday the 27th, but try to get them to me next week and I'll turn them around, okay? And I think that's a good starting point, start looking at people's language. Questions? Steve?
Well, a couple of things. I do think the form's important. Now, as a used motor vehicle dealer and a former board member, I can kind of go both ways. I'd love to have less paperwork. But I don't know if that's in the best interest of the consumer when we're trying to put a bright light on this form. We have a hard enough time getting the consumer to go through all the detail and documentation. They're excited about a new car. They're ready to go. How much is my payment? I think it's clear that it does speak to being a form. So, and I have no problem modifying E. I don't spot deliver, so this is not an issue for my stores. But this form has gone through, to the best of my knowledge, 2 rulemaking and 2 AG's offices in the past. I think it comports to the statute, and it provides for taking a deposit and converting it to a bailment. And dealers have relied upon that, and short of a statutory change or an appellate court case, I think, and that's how the board has ruled, and that's how we've relied upon that. So I think that has stood the test of time. I do think, contrary, and we're talking about 2 different kind of arguments here, or not arguments, but we have a used car at the time of delivery, and we have a new car at the time of delivery. And I do disagree. I think the delivery of a new car has nothing to do with demo miles. I think it immediately becomes a used car, and therefore that dealer is damaged and therefore entitled to a bailment agreement. I don't think they get to take that car back. Now, I know that that's not how it currently is interpreted, but that car comes back to them as a used car. They are damaged, and they're entitled to that bailment. But that's a totally different conversation.
Used cars and depreciation, not new or used versus legal definition.
Well, a better way
Right.
to say it is if you've got 2 identical vehicles sitting next to each other, they're both Chrysler 300s, one's got 700 miles on it, one's got 13, which one's got more value?
Right, yeah, I get that.
So the customer loses a 700 because you have to declare that it's under the warranty, so he's lost, there is depreciated
Well,
value.
there's also that, no, I think that a car gets delivered and it can come back with 100 miles on it and is a used car. That new car becomes a used car. The demo miles are demonstration miles. It's not a delivery, but that's, And I would suggest for years that the board and the division took that position. And maybe something has changed statutorily that I'm unaware of. But it's a form, let's clean it up, that's what this charge is. I'm all good with that. And I think that there's good language out there that industries can get behind and consumers can make clarification for consumers.
I'd like to get rid of the interest rate altogether in the form. I think it creates problems. It's currently interpreted all over the place by dealers. Some write the same rate that's in the retail installment sale contract, some write 21%, some write some other number in. There's no clear guidance as to what's supposed to be written in there. And frankly, I think it creates a potential TILA violation to write any interest rate in there. This may be the only point of agreement I have with Mr. Wincoop today, so.
Well, I would agree with.
For the record.
I agree with you on that too.
I don't, and in terms of our overall goal, Chris, of making this simple for consumers to understand what, it doesn't create simplicity, it doesn't create clarity. It only creates potential problems. So let's get rid of any mention of interest rate altogether. The interest rate disclosures are in the retail installment sale contract or the lease, where they belong. Let's leave them there. Let's get them out of this form.
I tend to agree. I think that's.
So it would just be miles?
Well, no, the interest, in terms of discussing the financing contingency, there'd be no discussion of interest rates.
I understand.
I mean,
You're
what the
saying
law
take it
is
on the
though.
form.
Right.
Right, in the form, there'll be no mention of interest rates.
So the only thing on the form would be days and miles.
For bailment.
For bailment.
We're talking about something different though.
Yeah.
I'm talking about financing contingency.
Yeah, he's talking about what's contained in D rather than what's contained in
We would
E.
be better off eliminating it altogether or leaving a ceiling and not having it be the same, because then it would also shed light on the fact that you're not guaranteed. Even though your contract reads 7.9, it's not guaranteed and it's up to 21%. So it needs to either have that or eliminate it
But
altogether.
the problem is the retail installment contracts now states specifically seller's right to cancel, and it's based upon the APR in there, so they can't assign the interest rate to,
Oh.
so that's why you got a conflict, and that's why you gotta get rid of
Well,
it.
from that, okay.
So that's why we
Okay.
get conflict.
The
Or they have
language
to
that
be
we
the
had
same.
discussed at the previous meeting really had to do with making sure the consumer was very aware that, you know, if that falls through, you must sign a new contract. That is optional, subject to negotiation. You're not required to sign a new contract. And that's the language that was more needed in there, not having a range of interest rates, which just creates problems.
Right. So, yeah, I mean, I think one of the things the form should state is if you can't get financed as on the original deal, you have the option to sign a new contract to buy the vehicle. And
you
that.
don't have to.
But you don't have to. And I think that's a freedom of contract issue that needs to be stated in there somehow.
Okay. I like that.
And I can't, there's 2 points. You raised the interest rate, there's another one. Oh, whether it's gotta be a separate form itself or incorporated into the buyer's order. I personally like a separate form. Whether that's by regulation.
You like it or
choice.
don't like it?
I do like it.
Okay.
I do like it.
I think it has to be a separate form, whether it's gotta be embedded in the regulations. I think that
Yeah.
the statutory scheme that creates it, K, says it has to be a separate form.
Or incorporated into the contract. 12-point type or larger, or 12-point type or 3 points larger than.
Well, I think it's a separate form that is incorporated in the contract, in my opinion, being purchase order. But I think it's gotta be a separate form according to that. I think there's also might be a problem with the interest rate because the section D says that it has to have something regarding interest rate, so.
It's generally why the contract's turned down, because the rate that you have on your contract is different than the rate that the bank's approved, and that's usually why you've got an issue.
So if we unembed the form, we are still looking at different language in D and E. But that different language in D and E will become part of the regulation. Now, the form is unembedded, but it becomes part of the regulation. Now, the consumer's never gonna read the regulation, obviously, they're gonna go to the form, okay? But that's, anyway, that's just a little, here again, that's a little bit of my pet peeve. It just seems,
Regulation by form is not ideal.
it seems the form embedded seems a little,
I agree,
I
I
would
concur.
completely agree.
Rick, back to your point on the interest rate as specified in subsection D of the statute, that it mentions at a rate not greater than a certain annual percentage rate. Why don't we draft some language that incorporates the interest rate stated in the retail installment sale contract?
Well, I think K also gives you the out. If what Mike and I are saying is right, that's not applicable if you've got a executed risk, then it's not really an issue.
But what if you're not right about that?
I find that hard to believe.
Best line of the
The thing I would say on that is, I mean, I guess there's some legal technicalities there about that, but from the consumer transparency issue that we're really all focused on here, you know, the whole problem is that we've talked about is when things get embedded in the primary contracts, they don't get read. And because of the confusion surrounding guarantee of financing, it really should be a separate form that is clear, that is signed separately, that is just one more way we make it something that the consumer might actually read and get their attention at the time of signing because of the issues surrounding this. So I mean, I actually agree that it should be a separate form and not just be another little disclosure that's in the primary contract.
Let me give you a perfect example. And Tammy called me on this, and I haven't called her back on it. She called me on this on an email. She's exactly, well, she didn't say it this way, but I'm saying that there was a mess up. When the form is embedded like this, any change to the form, whatever it is, any change to the form probably has to go through a rulemaking process, any change at all. This form, as it appears, went through a change. The change was required by the governor's office, not specifically to this form, but all forms had to change because any form that had, number one is the state seal on it, and this form didn't, but if it had the state seal came off of there. If it had the Department of Revenue seal, that came off of there. In this particular case, our address, our mailing address changed on this form from I think 1881 Pierce, or every one of our forms, to a P.O. box. That was a requirement by the governor's office or the Department of Revenue. So there was a change made to that, not subsequent, not what's the word I'm substitute, but there was a change to the way the form sort of looks. It's still pretty close. And what they did was they then made the form an executable PDF, which that was another directive from the governor's office or this committee the governor put. Every form that is possible to make an executable PDF needs to be made an executable PDF. So A, B, C, D, E, where they got the little signature lines, now has a little block there where somebody could actually do this on the computer, okay? Anyway, so there was a change to that, and so I'm answering your email of a couple of weeks ago. There was, so then the whole issue is when that happens, who buys forms, who sells forms, and all of that. I don't know how that all came apart. We have a division within our government called graphics. When Chris made the call, they had no idea that these forms were being sold. That's something that happened years ago. ABC Forms had a contract years ago. Our graphics,
I kicked a hornet's nest.
they didn't even know that. Okay, so when they changed forms, did they notify ABC Graphics or whatever? But we did log on after your email. We did log on to ABC Graphics, and they have the updated forms at least on their website.
They were notified. I work with Julie down there all the time.
Okay.
They were notified. Because remember I showed that to you when it first came out? I said, did you see this?
I don't remember, but yeah,
Yes.
okay.
It was yeah, but they did. Because she's the one that, they went ahead and printed the new form.
So that's the reason that it was a change in address and the thing of executable PDF. There was no change to any of the language in there. But when that happened, because it's embedded, we should have went through rulemaking because it's changed in the form.
Which is another reason to unembed this thing.
Or tell the governor to knock it off.
Oh, yeah. Because we don't want to work anymore.
Steve, would you call him?
All right, so I know
Bye,
Tammy has to
Tammy.
leave. Any other comments that, we still got a few minutes here, any other comments anybody wants to make? It's okay. Okay. If not, email me that stuff when you get a chance. I'll turn it around. We'll see you all at 1 o'clock on Thursday the 29th. Again, before we turn the
Except
record. Except, again, before I, thank you for your participation. I can't tell you, I can't express how much I appreciate your participation. That is real, that's from the heart. Thank you very much, okay, number one. Thank you for the professionalism here. We have a lot of debate, we have differences of opinion. You all conducted yourself very professional day in arguing your side of, and it was a good debate moving forward. Thank you very much. Meeting adjourned.
I was trying to do a little homework last night and went on to the